Very good afternoon, everyone. Welcome to ABC Learning. Today is the final class of our day on the Advanced Diploma of Intellectual Property. We will be discussing the trade secrets, and we have with us Mr. Ashok. Welcome again, Ashok, to ABC Learning. We had some amazing sessions with you in the past as well, and I would like to introduce you now. Ashok is a dispute resolution counsel, has represented clients in the food, healthcare, pharmaceuticals, aerospace, defense, and technology, banking, and financial services, to name a few. His work in the field of intellectual property rights involves not only advising and assisting clients in protecting and commercially exploiting intangible assets, but also in representing clients in various IP litigations involving trademarks, copyrights, and trade secrets. So, thanks, Ashok, for joining us today. We can begin with the session now, and over to you. Thank you so much.
Thank you so much, Dr. Anchal. I will be able to share my screen now. Yes,
Sure.
I can. Thank you. Okay. Can everyone see the screen in front of them?
Yeah, I can see.
Okay, perfect. So, in the course of the next 1 hour, 20 minutes from the looks of it, I will try and run you through one of the most underrated but valuable forms of intellectual property, which is trade secrets and confidential information. For anyone who's been part of the legal services sector or part of being in business, one of the common things that we would have come across is something called as a non-disclosure agreement or a confidentiality agreement. Right, and these are very ubiquitous. They are it's signed almost without looking into what the contents are. And there's almost always this sense that once you've signed an NDA, everything is safe and everything is well protected. Nothing could be further from the truth. So we're going to examine how practically something like trade secrets are protected. How do you enforce them? What are the nuances of it? Why trade secrets over other forms of intellectual property protection? So this will largely be the theme of today's conversation. And hopefully, I make this endeavor in every session that we will try and keep this as interactive as possible. So when I ask a question, and if any of you feel that you want to volunteer an answer, please feel free to just use the raise hand option and I will come to you. I've also been told that I tend to be very fast in the way I run through my PPT. So if you feel that I must pause, re-explain something, do not hesitate to just quickly drop in a message or raise your hand, and I will immediately circle back to what I was doing earlier. Okay, with that we shall start. Thank you. Okay, so the broad topics that we will cover: what are trade secrets and confidential information? How do we effectively protect them? How do we enforce them? Because your degree of protection or the water tightness of a contract around confidentiality is only as good as your ability to enforce the contract or enforce your confidential information if the need comes down to it. How do you effectively do that in our legal system is obviously something that we will explore. The other tricky subject, which I think is now resulting in a fair amount of clarity in jurisprudence, is how do you really manage confidential information and trade secrets during the course of legal proceedings, especially during the course of trial? The reason being that court proceedings, by their very definition, are matters of public record. It is possible for a person from the general public to watch proceedings, to apply for copies of court papers, whatever is filed in court, and then how do you really manage your confidential information if you decide to litigate it in the court of law? So we will explore that aspect as well, and of course the concluding remarks on what do we do about it. The oldest form of intellectual property protection, to my mind, especially when it came to protecting key aspects of a business's success, is probably trade secrets and confidential information. And I think one of the best examples we can think of is the hospitality industry and the food and beverage industry. Even before the Crown in Europe decided to recognize patents, it was common for restaurateurs to hold on to recipes and ensure that it stays within the family and is not given out to the general public. And oftentimes, that was the key to their success. Uh, in the country today, even now, you will see that trade secrets and confidential information continue to be a very critical part of a business's IP protection strategy. The best example I can think of is the all-time favorite biryani. And you will see that so many restaurants in the country will probably disclose maybe 80 to 90% of the recipe when they actually come on air and discuss how the biryani is made. But you will always notice that there is a one secret ingredient, with maybe the masala, maybe a syrup. And they will always say that, look, this is a closely guarded family secret and I'm not going to let it out. There have, in fact, been restaurants where, because the chef carried the secret recipe with him over to the grave, the entire value proposition of the restaurant itself has come to an end. Right? And you will notice then that trade secrets and confidential information are more common than we care to acknowledge. It's all around us. And I think that's also something that we need to recognize. It's not always a case where the trade secret is a wonderful piece of algorithm or a software code or a new semiconductor design. The prevalence of this form of IP protection is available across. And sometimes it can be as small as the recipe for food. It can be as intermediate as, how do you optimize the supply chain for supplying linen to a hospital? It can be as large scale and impactful as artificial intelligence and the code that has kind of enabled it to be smarter and more intuitive. It is honestly that diverse and that widespread in its application and usage. Right? There are certain reasons for it as well, and we will come to that at a later stage. But to give you a few famous examples of trade secrets and confidential information in the world, the recipe for the cinnamon roll that Cinnabon has, the kind of cinnamon that goes into it and the preparation that goes into it is again a very closely guarded trade secret. And Cinnabon is a very well-known brand in the US, especially. Right? So, example of a closely guarded recipe that's enabled the success of the entire franchise. The next example I can think of is the self-driving technology. Google and Uber fought hard over it, and at the heart of that litigation was protection of trade secrets and confidential information. And we will dwell into some of the nuances of that case at a later stage, because it is an extremely complex litigation, which I believe eventually got settled. But long story short, it is a prime example of the practical challenges of protecting trade secrets and confidential information. The search engine algorithm of Google, and you can today the word Google it is almost synonymous with an internet search engine, which is a very bad way of describing a trademark for the record. But bottom line is, you'll see how successful the search engine has been. And some of us may not understand how critical or how difficult it was to achieve the level of intelligence the Google search engine has achieved. And I'll give you a simple example. When the Boston Marathon bombings took place, the culprits, when they were finally identified, the US authorities realized that they were actually already on the watch list of the Department of Homeland Security. But the name, while being entered into the database of Department of Homeland Security, had a small variation in the spelling as opposed to the spelling on the passport of the concerned culprits. So when they went through the immigration system, because of the minor change in the spelling, the computers did not flag them off as potential red flags, right? And that's how they entered into the country. Now, this problem of a minor change in the spelling resulting in a search engine not being able to deliver the desired results, Google has overcome it using something called as big data, right? And that's also because their algorithms are that smart and that intuitive. And the fact that they have chosen to protect that as trade secrets and confidential information and not patents really tells you how powerful this entire IP can be as a form of protection. Right? And the last example that I can think of is Coca-Cola. Again, what exactly goes into that soft drink remains a closely guarded secret. often to the detriment of the people who feel that they pose a threat to the health of general public. But nevertheless, if you can think of one of the strongest brands in the world, and I presume Coca-Cola is going to be one amongst the top, if not the top itself. One of the things that has enabled the soft drink to become as popular and as widespread is perhaps the recipe that they have. And a part of that recipe continues to be a closely guarded secret, which very few people within the company know. So it does tell you that the relationship between the success of a brand and trade secrets and confidential information as a form of IP, the link is there, right? But before we conclude that this is perhaps the best way to protect IP, we must also realize that these brands have invested big money to protect the IP, right, which is a trade secret. And therein lies the key to the success of the trade secret in contributing to the success of the business. It's the way in which it is protected, right? Something that's closely guarded, closely kept to one's chest, likely to be lesser known to the outside public, and therefore gives me that little bit of an edge and an advantage. Any questions so far? Okay. So what is a trade secret or a confidential information? And sometimes these are also interchangeably used. In fact, I myself I'm prone to making that mistake, for the lack of a better word. So there are multiple definitions, but what complicates the matter in India is the fact that we don't have a statute specifically addressing the protection of trade secrets or confidential information. And this can make things a little complicated, especially when there is no statutory regime for it. But in front of you on the screen, you will see three definitions carved out of two different sources. One, of course, is the legislation in the United States that deals with trade secrets and confidential information. The other two are from Black's Law Dictionary. But if you notice the three definitions, and I'm not going to read it out, but certain things come to our mind as a pattern, right? One, it must be something that's not very well known outside of the organization. It could be anything. It could be technical. It could be business. It could be any kind of information that is generally not something known to the outside public. It must represent some economic value, right? So if tomorrow an organization has knowledge of something that may or may not result in a significant business advantage, right? It may not really represent a huge value in terms of trade secret protection, right? And it's difficult to think of information within an organizational setting that could possibly be deprived of economic value. But for example, to take it to a more generic example, personal knowledge of the happenings in the lives of the management, right? Now, that could perhaps be something known only to a few people, but it really has no economic value outside of it, right? In those circumstances, to be able to protect that as confidential information is a tad bit difficult, maybe under the doctrine of privacy instead. But to qualify as trade secrets and confidential information, the essence is that there is economic value in the information itself. And last but not the least, it is also important to establish some steps that have been taken to protect or guard the trade secret. And because obviously, if something is available for people to freely access, take out, and borrow and use, there is no effort to guard the secrecy of the information, then it is not a secret. Right? So that being the case, how effectively does the organization put in measures to protect the trade secret defines whether or not it is a trade secret or confidential information, right? And it is not a case where, in fact, I would go one step further. I would venture to say, if there is no steps taken to protect something, that something cannot be a trade secret, right? That's how critical this entire concept of putting in place those measures are. Right? And it's very important that people both in the industry and both in the legal services sector understand this, because again, the most common mistake that I see is we have an NDA, everything is hunky-dory. Couldn't be further from the truth. It's very, very important to go many steps beyond that. Any questions so far?
No.
Okay. I do recognize that it is a Sunday, so I hope the lack of questions is not on account of the need to expeditiously be done with this.
No, I'll come to you later. Let us
All
complete.
right. Okay. So, one of the illustrious cases which kind of aptly summarizes the principles of determining when there is confidential information that has arisen is the case of Bombay Dyeing Company versus Meher Karan Singh. And this case is very interesting because it was a suit filed for protection of a variety of trade secrets. On one hand, there was something technical. On the other hand, it was also business related information. So the court analyzed the jurisprudence from across the globe, looked at definitions from quite a few regions, and finally summarized these 6 principles to determine when there's a trade secret. One, the extent to which the information is known outside the business, obviously very critical to determine if it is secretive enough or not. The extent to which it is known to those inside of the business. Now, this is very interesting, right? If your business is a fairly small organization, say 10 employees or less, or maybe 10 to 300 or 400 employees, right? So the question then arises, how many of your people have a need to know the confidential information? And that is something that the management has to answer for itself. How many of these fellows in the organization really have a need to know the core elements of the trade secret or confidential information? So let's quickly jump to the example of the restaurant, right? There is a head chef, there is a sous chef, there's probably somebody only looking at doing desserts. There's a fair amount of division of labor within the kitchen itself. Now, if the owner of the restaurant and the chef of the restaurant haven't taken steps to ensure that even within their own organizations, there's not too many people who know the exact recipe of the biryani that everybody loves, then chances are that they're really not serious about keeping the information secretive. Right? Because fortunately or unfortunately, the more trust the owner of the business has in the people to deliver the trade secret, chances are that in the result, he has unwittingly compromised the secrecy of the information itself. So oftentimes, and there's no blanket rule saying that you should have only 2 people who know the information, or 3 people to know the information, or 10 or 20. Right? It's a very contextual question. In the context of your business, how many people really have a need to know? And how do we ensure that other than the need to know circle, we don't end up giving the information to the others? Right? Now, this also serves a very critical function other than just the legal element that we're looking at. If there are a greater body of people that are aware of the trade secret and confidential information, traceability of the leak becomes that much more difficult, because your suspect pool is no longer 2 or 3, it becomes 300, 400, or maybe in the thousands. Right? So when you essentially get down to the investigation component, how do we really figure out who leaked the information? You essentially go back to knowing and asking yourself how many people know it in the first place. Greater the numbers, the greater the chances of the investigation not resulting in a desired outcome of truth. Right? So managing and controlling the proliferation of the information within the organization is absolutely as critical as it is to prevent the proliferation of the information outside. Okay? Now, this brings us to the next point, the precautions taken by the holder of the trade secret to guard the secrecy of the information. And this can't be more important. I was appearing for a plaintiff in a matter involving a certain engineering design being taken out by the employee. And during the course of the trial, it so happened to emerge that every employee within the organization had password protected computers being assigned to them. And for them to access the designs of the company, they essentially have to come to the office, use the desktop that the organization has provided, log in using the username and password, and then access it. And we were quite happy with the system that was put in place, because obviously it means that the report that I've gotten tracing the lead to a particular IP address and to a particular system is now ready evidence to be used in the court of law. But during the course of the trial, it also emerged that the username and password for each of the system was written on the table on which it was placed. right? Which then brings us to the important issue of how do you ensure that it was actually that gentleman, the defendant, who actually used the computer system to pull out the engineering design. Could have been anybody within the organization. It's another thing that this allegation was not proven by the defense, and it helped us to eventually prevail. But it just tells you that something that was done out of convenience, that, please don't forget your username and password, and therefore this is what it is, and it's written on your desk table, could have potentially compromised the trade secret worth millions of dollars for my client, right? And all because the employees were not trained to not write their username and password on the table, and were not taught the value of keeping that information secretive. Right? So these kind of access related controls that the organization puts in place, is there biometric entry into the organization? Are the computers sufficiently protected by firewalls? If these questions are not addressed by the plaintiff while trying to enforce the confidential information, the best NDA is absolutely useless in the court of law. Right? So something to keep in mind. And then, of course, the next component goes back to the earlier discussion around economic value. The savings affected and the value to the holder in having the information as against competitors. Now, this is a relative question that the court is posing, right? We need not establish that this trade secret is going to fetch me millions and billions of dollars in revenue. What I need to establish is that, look, using this information, I am able to increase the profit margin that I'm able to make by 10 rupees. Whereas without this information, my competitors are deprived of the 10 rupees worth of value addition in the process. Right? So it's highly contextual to each industry. So it's not that the trade secret has to be valuable as against an objective standard. You just have to establish that for my business, given the context and the setting and the size and the scale, this information results in this kind of value addition. And even the owner of the local Golgappa shop will still be able to employ this as an effective measure of protection if he realizes that a competitor is trying to access that one garam masala recipe that could make the Golgappa a little tastier. Right. So we have to really look at the lowest common denominator and assume that even to them, this IP is valuable and it can be a potential tool. Right? And last but not the least, and this is very, very critical, the amount of time and expense it would take for others to acquire and duplicate the information. Right? Because this again goes back to the effort that has been invested by the owner to actually develop this information. So essentially, the economic value of the asset is also defined by the amount of effort that has gone into developing it. How much of money was spent into R&D? How many manpower were involved in terms of being able to, how much of human power was involved in terms of being able to develop the trade secret in the first place? These metrics will then go into determining the savings affected, right? Now, why the amount of time and expense is important is because when you ask for the final relief in your suit or in your effort to protect your trade secret from a court of law, from an arbitrator, you will ask for damages, account of profits, injunctions, so on and so forth. While measuring the amount of time the injunction must be enforced, or the amount of damages to be given to you as a result of the misappropriation of the trade secret, it can't be a case where the court comes back and say that, look, if this trade secret were licensed to the defendant for the next 100 years, this is the royalty you would have made. So I will let the defendant give you that much of royalty for the next 100 years, because that will then become not compensation, but a penalty. So the courts will essentially ask the question, if the competitor had to develop this on their own, how much time and effort would it have taken them? And the court will then come back and say, that's the time during which you will get the royalty. It could be 5 years, it could be 2 years, it could be 3 years. But to expect that the trade secret litigation will result in a perpetual relief is slightly misplaced, because somewhere the law will presume that if another person puts sufficient time, effort, and energy, original effort, time, and energy, what you have developed, they could perhaps develop it on their own. Right? So it is always a question of the time and the amount of time it would have taken for a competitor to develop this is essentially one of the metrics employed to determine the amount of compensation or the measure of relief that you're going to get for your trade secret. Right? So 6 factors. Any questions so far? And just a general side note on the subject of damages and compensation, right? Which is that you can't expect litigation in India to take care of you for the rest of your life. On the contrary, the litigation is probably going to take a lot of effort from you for the rest of your life, but it will never be the thing that will ensure that you live your life comfortably and never have to work again. That's not the Indian legal system. The measure of relief in Indian legal system is always compensatory in nature. It's never punitive. And there's always a very conservative approach in terms of granting relief. Right? So the idea is to really just, give you some immediate short-term measures of compensation as opposed to ensuring that, you never have to work again in your life. Right? That's probably some jurisdictions in the US, but not in India. So let's assume that you are working with an organization and they're asking you this all-important question. We have developed something. Why do we look at trade secrets? Why not look at something else, such as, say, patents? Now, there are certain advantages to a trade secret, right? If you look at registering a patent is essentially going to be country-specific. So you're going to probably have it limited to an India or maybe certain parts of the world where you have enough money to prosecute a patent application. But beyond the borders of those countries, your invention is left completely exposed. Right? Now, the problem here is that because you've applied for this patent, it's also been published in the Gazette of the local patent office. Now, once it is published in the Gazette, it's also probably out on the internet. Now, if your patent protection extends to India and the US, but there's somebody in the United Kingdom who's quite keen on exploring what this technology is, to get that person to reverse engineer the entire product, the starting point is going to be the patent application that you yourself have publicized. Right? Now, that means that if you want to achieve global worldwide protection for your invention, you have to look at least 180 patent applications around the globe, which is obviously an extremely cumbersome and difficult exercise and almost physically impossible to achieve. Right? So this is the limiting factor of patents. Now, look at trade secrets and confidential information on the other hand. A brand like KFC successfully went from the US to almost the entire world just on the strength of Colonel Sanders' recipe for the chicken being kept secretive and confidential. Right? And today, I know there is a Kothnur fried chicken in JP Nagar of Bangalore, right? Also called itself a KFC. But they can try and imitate KFC as much as they want, but they can never become the size that KFC is today, right? So there are certain advantages that trade secrets represent in terms of geographical boundaries not being a limiting factor, right? Which becomes a limiting factor for more traditional forms of IP protection. Even with copyright, which has a slightly more global protection or say trade secrets, copyright protection depends upon the compliance of Berne Convention. Is there reciprocity between the two countries in which the copyright enforcement is involved? But in the absence of that reciprocal arrangement, the Berne Convention will probably not help you in enforcing your copyright outside of the country. With trademark protection, both in India and in the US, we saw massive brands which collapsed in their efforts to stop local businesses from using their trademarks. One example that I can think of is Hilton Hotels. Hilton Hotels, despite being as big as they are elsewhere in the globe, could not stop a gentleman in Rajasthan from starting up Hilton Hotels because they could not establish the presence of local goodwill. The other big example is Toyota Prius. Prius is a big brand outside, but they couldn't stop a person in India from using Prius because the court said you have to establish local goodwill. Same thing with the US. ITC versus Panchgani, the Court of Appeals in New York did not support the plaintiff when the well-known mark Panchgani was sought to be enforced because there was no local goodwill. But you look at trade secrets on the other hand, right? If the recipe of that Panchgani restaurant was secretive, chances are they could have probably gone to somebody in New York and said that, look, I'll give you the recipe. I will license it to you. And you can also then, you'll have to use my trademark in the process, right? And it could have been an able way to actually expand the entire brand into a different jurisdiction. So geographical boundaries, which could be limiting factors for other conventional forms of IP protection, is no longer a limiting factor for trade secrets. But it then also raises a different challenge, which I'll come to in the cons. Right? There's no expiry date for a trade secret, as borne by how old KFC is and how old Coca-Cola is. Right? As long as somebody else does not have the smarts to generate the recipe on their own, the brand continues to piggy bank on the trade secret for its success. There is no necessity of public disclosure, which probably explains why the search engine algorithm of Google has not been disclosed in the public, right, through a patent application. Then, most important, because what is in here is what is most valuable, the original promoter or the original founder who has the trade secret will always be relevant in the organization. You could still envision an Apple kicking out Steve Jobs in the 90s, right? And of course, he made a spectacular comeback. That's a different issue. But in the case of trade secrets and confidential information, it is absolutely critical to have the guy who actually, or the lady who actually has the information, remain in a key managerial position or remain, joining hands with the organization for the organization's success. So it's a great way for the original founders of the business to ensure that regardless of how accessible the capital of the organization is to the public, they can never be dispensed with simply because of bringing this value proposition to the table. Right. So these are some advantages that trade secrets have over conventional forms of IP. But there are also corresponding vulnerabilities that we need to be aware of. A patent is more resilient, right? Unless and until the technology itself becomes outdated and is no longer relevant for the industry, chances are that as long as the patent is around, even if one or two people get to know how you're working the invention, you can go ahead and stop them, right? So that it gives you that stable foundation to base your entire business on. But in trade secrets, the moment it leaks to one person outside of the confidentiality framework, either an agreement or an employment agreement or a trade secret policy or a common law duty of confidence, it essentially means that the value of your asset is lost forever, right? Because that one person who got access to it, who did not have a legal duty either under a contract or under law to misuse it or to leak it, he can then ensure that your business is brought to its knees, right? So the value of the trade secret lies in secrecy. Loss of secrecy vis-a-vis even one person essentially means that your confidential information is useless, right? So the other problem, of course, is that not all countries have specific legislations addressing trade secrets and confidential information. So the absence of a statutory framework results in certain enhanced compliance cost, right? You have to invest in good NDAs, you have to invest in good trade secret policies, you need to invest in the physical and the electronic infrastructure to keep the trade secret a secret. So obviously, the measure of individual responsibility increases manifold when you don't have a statutory framework protecting you. There is considerable difficulty in enforcement. Trade secrets are inherently very difficult to enforce, and this is a problem statement we'll deal with a little later. But to give you an example, if Google has an algorithm for a search engine and it wants to stop somebody else, an ex-employee, from using that same algorithm, they have to file a claim somewhere, either before an arbitrator or before a court of law, right? So that essentially means that stakeholders outside of the organization, like the judge, the opposing counsel, the bench clerk, and the entire ecosystem of the dispute resolution proceeding now know that there is a leakage of information. They might even know bits and pieces of what the information is. And your difficulty is that if you describe what is lost in great detail within your court record, that public record essentially means that your trade secret is lost. But if you don't describe it in sufficient detail, the defendant doesn't even know what allegation he is rebutting. If I say that, look, you have taken my confidential information and walked away, he has to either say that I am rebutting it or I'm not. Maybe he has taken customer information, but not the software. Right? So if you don't give him the illustrious details that is necessary for him to rebut, then it is insufficient notice, which means the prima facie case is no longer in the picture. So you could end up losing just on the ground alone. So on one hand, you have to disclose, but you have to not disclose too much. striking that balance in between is exactly what makes trade secret enforcement that difficult, right? As opposed to a patent where your claims are there, your grant certificate is there, your patent application is available, uh, easier to enforce, right? So the other problem also is scalability and survivability. As much as the original entrepreneur who has the trade secret is relevant, he dies, the business dies, right? And take a look at franchise as a model of business expansion. How does a franchise really expand? When you come back and tell people that, look, I have the brand, I have a know-how, I have systems in place to run a particular kind of business. I want you to be a stakeholder in this business, right? So human relationship, or unfortunately, the lack of a better way of doing it, depends, trust is built on the basis of disclosure, right? The oldest enterprises that were formed, which were villages, were formed on the basis of people gossiping about each other, right? And this is famously captured in Yuval Noah Harari's book, Sapiens. Now, that is because the more information you have about the other person, the more trustworthy the other person is. And this is critical to building business enterprises, right? To be able to scale, you need to bring in more stakeholders, and you want those stakeholders to not only come in but stay with you, which means that some level of skin in the game is necessary. That skin in the game often means that you're either parting with capital or with information, and you start that entire journey by asking yourself, how do I trust this person? Do I have enough information about them? And that process is what we call as due diligence. So now due diligence obviously requires information disclosure. Information disclosure essentially means that your trade secrets are vulnerable. You don't do that, you don't expand, but you do that, your trade secret is vulnerable. This is the problem statement around trade secrets that we have to practically try and solve. Right? Any questions so far?
Trade secret, I mean, it cannot be registered or something, correct?
So the Indian legal framework does not have a mechanism for registration of a trade secret, right? And I would, in fact, I would probably go one step further and say that I don't want a registration mechanism for trade secrets, because no registration is possible without disclosure. And I would much rather not disclose it to the government if I have to register, because I mean, as much as I believe that as a lawyer I should trust and believe in the legal system, I am not entirely sure that the information is secure if it is in the hands of the government, right? Because practically speaking, the kind of systems to be put in place for that level of data security, I'm not entirely sure whether something can be dedicated for the protection of trade secrets.
Okay, that means if I cannot register, say, for some system or process, that it cannot be enforceable by law. But leaking is, I think, possible everywhere. Suppose if I have a trade secret and I am
Right.
maintaining this, so leaking may be possible, or which can be enforceable.
So the way it works is the English system of common law does not prescribe registration as the foundation for an enforcement action, right? It actually looks, there are doctrines of equity that protect you even if registration is not done. For example, passing off in the context of trademarks. Even with confidential information and trade secrets, the enforcement is done through two principal channels. One is trade secrets and confidential information is enforced as an enforcement of the confidentiality agreement, which is an action under the Indian Contract Act. Alternatively, in the absence of a contract, there is something called as the common law of confidence, which says that if the environment or the framework within which the trade secret is disclosed reveals that there was some form of confidentiality that was expected, or that there was some kind of a fiduciary relationship there, then even if there is no contractual obligation, the person receiving the confidential information has a duty to keep it confidential. Right. So there are ways in which the legal systems have protected the enforcement of confidential information, even in the absence of a contract. With the presence of a contract, then it's a straightforward case of enforcing the contract itself. And so registration is not really critical for either of these two. I mean, there is no system for registration, but I don't think it should become critical to have registration to enforce a trade secret. it defeats the purpose is what my personal view on the matter is. Any other questions? So the non-disclosure agreement. Before we even go into this, let me ask all of you, how many of you have had to already sign NDAs or have probably come across one? And because I'm very certain that a lot of us have already been through one or more NDAs in our lives. Right? Any
No, I do not.
no NDA yet? Okay, good for
No.
you. Anyone else who wants to volunteer their experience with an NDA?
When I joined an organization, I had to sign a non-disclosure agreement that whatever information that you're working on and shouldn't go outside the organization. So in that sense, I have signed an NDA.
Perfect. So I signed my first NDA as an intern in an IP management company at first year of law school. And I was supremely excited and stoked because in the NDA, they said they used the nomenclature consultant to describe me. And I was on Cloud9 saying that I'm consulting with a company in first year of law school. But the funny thing was that they gave me an agreement. I didn't even look into it and I signed it. And the reason why I was as confident was actually I was a minor when I signed the NDA. And the organization hadn't even done that due diligence because I was actually the age of 17 then. Right. So sometimes, this is a classic example of how casual our approach towards contracts are. Right. The clauses were watertight, but just the age verification of the quote unquote consultant was not undertaken before the NDA was signed. So brings me to the first point, right, which is establishing the fiduciary context for disclosure. Your NDA, what is the purpose of entering into an NDA, right? Obviously, there's a very elaborate definition of confidential information. There are duties stipulated, not to disclose, not to do this, not to do that, so on and so forth. There are measures prescribed on what can be done if there is a breach of the agreement. So it is a fairly elaborate document. But I think one thing that most NDA authors tend to miss out on is that the primary purpose of the NDA is to convey to the entire world that, look, because this person has inspired trust in me, I have agreed to disclose my confidential information to her or him. Right? Now, if the fiduciary context is established, even the most casually worded NDA probably will be easier to enforce. But if the fiduciary context for the disclosure is not adequately reflected in the NDA itself, chances are that the enforcement actions will have a lot of other complications to address. So the first step is to ensure that that little section before the clauses start, where it goes whereas, the background or the recitals to the agreement. For an NDA, that is actually quite critical. You need to explain the background, you need to provide context, you need to be able to establish that there is a fiduciary context for the disclosure. And that in return will carry you at least 20 to 25% of the distance when you actually have to enforce a trade secret, right? So templates are great. Absolutely love it. Makes our jobs easier as lawyers and legal services professionals. But templates are also a trap. So the difference between template being a tool for saving time and the template being a trap is the amount of effort that we are putting into it to determine if the template will actually reflect the context or not. Right? So establishing the fiduciary context is the first rule of a good NDA. Right? Now, the next rule, which is to very critical, the lesser one knows, the lesser one leaks. Right? So this is again, the reason why we say this is let's look at a simple NDA between an investor, right, and a startup. Now, the startup is being asked to establish a fiduciary relationship with the investor, right? Because nothing signifies trust in a capitalist economy than people putting money into each other's business. So obviously that's something that's very special. So now for the investor to make that headway, he needs to validate that the technology is probably has business potential, and two, that the business plan of the company itself is sound and is likely to carry the business forward and yield the returns, right? Now, in the context of this relationship, a startup and the investor have to ask themselves how much of information is really required before the investment agreement is actually signed. The reason why this is important is because if there is more information being given to the investor than what is necessary for the due diligence, not only is the startup vulnerable in terms of the ability of the trade secret to proliferate in the open market, but tomorrow if there is a leak, even the investor has to worry about needless allegations of trade secret disclosure on its part. Right? So it is in the interest of both parties to ask themselves, how much of information should we really disclose for the purposes of achieving the purpose set out in the NDA, and ensure that the disclosure is limited only to that extent. Anything more is not needed, and two, unnecessarily could become potential for trouble, right? So how do you balance this? You ask yourself, there is a business relationship that we're trying to achieve. How much of sufficient disclosure is sufficient for establishing that relationship? And you arrest the disclosure only to that extent. This is as much an onus on the language of the document as it is in terms of training your employees who have to administer and manage the document later on, right? So NDAs are more about administration and managing NDAs than about drafting of the NDA itself. Great NDA drafting, fantastic, but poorly managed and administered, useless. Right? Now, what are the concerns you're trying to address? This is fairly easy. You want to prevent leakage of information. You want to prevent unsanctioned usage. You're giving your investor the access to the technology for them to validate the business potential, but they're actually using that to help another startup verify and validate their own competing technology. That is unsanctioned use, right? Or they take that and they decide to publish a fantastic report with McKinsey and company for showing what the industry trend is and how much valuation that industry trend is going to achieve. Unsanctioned usage again. So we have to be very clear about not just leakage, but also usage. So any usage of the information by the investor for anything other than evaluating the organization for a potential investment is unsanctioned use. So how effective is the language of the NDA conveying that is the next question that you need to answer. The other thing to also remember is reverse engineering, right? So sometimes when you're able to take a look at something long enough, you're also able to figure out how it works and reverse engineer the whole process, right? So even in the context of trade secrets and confidential information, that is something that you need to consciously address, right? How do you prevent the reverse engineering of the trade secret and confidential information? And last but not the least, unauthorized storage, right? And these days, this is a far bigger problem because companies, as part of the cybersecurity policy, also have measures put in place for auto backing up of data and software on different servers, right? So when the NDA has finally come to an end and you ask for either return of the confidential information or deletion of it, chances are that there are archival copies of that very same information sitting in some server that you're not even aware of. Right. So how do you address that is again the next leg of the question for the draftsman of the NDA. Right. So then, of course, what you also need to realize is that the risk of breach implies a significant loss of asset. So you have to also then stipulate that, though it need not be explicitly set in the contract to this effect, but you need to advise both the parties in the agreement that if something happens in the context of a breach, damages alone may not be sufficient, and the concerned person aggrieved may have more remedies available to him, such as equitable relief for specific performance, injunctions, so on and so forth. And last but not the least, choosing the appropriate dispute resolution mechanism for your NDA is also very critical, right? Because look, arbitrations are maybe slightly more advantageous than conventional courts of law for trade secrets, because there is assurance of confidentiality of the proceedings, unlike a court of law. Right? But enforcement of arbitral awards also come with their share of challenges. Appointment of arbitrators will take a certain amount of time. Then you have to invoke your interim measures under Section 9 of the Arbitration and Conciliation Act, which means you again come back to the court of law. Right? So you'll have to look at what the dispute resolution setting is in the relevant jurisdiction at that point of time, and decide based on the cost and all these other practical measures whether you want to stipulate arbitration or you want to stipulate maybe a court of law resolution process. But if you don't make that effort, you can see some very amusing outcomes. I was dealing with an NDA where our client was going to license software to the customer. And the NDA was more or less a formality. There was actually no disclosure of confidential information that was going to happen. There was going to be an NDA post which a software license agreement was going to be signed. And the software license agreement anyway stipulated a separate set of confidentiality measures. But the customer insisted that we have to take a look at an NDA. And to my horror, the NDA for something as inconsequential as this stipulated dispute resolution before a panel of 5 arbitrators who are to be retired judges of either the Supreme Court or the High Court of the relevant state. And to imagine a scenario where I'm going to be spending lakhs and crores of rupees of dispute over an NDA of this nature was unbelievable. And then we finally went back and said, look, why do you need a 5-member arbitral panel for this? Let us just do a sole arbitrator before an institutional arbitration center and keep the cost at a minimum. And the internal legal counsel was absolutely adamant, saying that this is a standard format. We can't tinker with it without getting global approvals. And we stood our ground. And I remember the agreement signing got delayed by at least 4 to 6 months just on this to and fro. Right? So sometimes you really have to ask yourself, whether the templates are the best idea or not. And this is another example of it. So always ask yourself, what is the best means of dispute resolution mechanism? Customize a mechanism specific to each NDA. Don't be in a hurry to freeze something and gloss it over. Ask yourself, what is the data going to be that's going to be disclosed? Ask yourself, what is the value of that relationship? How much of economics are involved? Ask yourselves the practicality of enforcing these measures. Where is the best place to do it? And then put yourself in the shoes of the draftsman and say, okay, this is the best dispute resolution mechanism. One formula will not work for everything. Any questions so far? Okay. Now, the other thing to do, which is almost always neglected, is the policy for trade secrets and confidential information. And this is so very important, because when you have to go to the court of law or to the arbitrator and say that I not only have an NDA, but I've actually taken steps to protect the secrecy of the information. And then the arbitrator or the defense counsel will come back and say, hey, what steps have you taken? Please show it. Right. And then how do you prove that? Right. Do you take a video of the watchman checking the bag for electronic storage devices? Do you show photographs being taken of somebody's laptop not being allowed inside the premises? So obviously there are more dignified ways of doing it. And one of the best ways to do this is to have a rock solid trade secret policy in place. Right now, this will address things like information security, access control. Right. So, for example, have you put in place a biometric lock to ensure that you're able to figure out who's coming in and out of the area where the sensitive engineering designs are housed? So that will then be stipulated in the policy, saying that every office will have a minimum set of access control measures put in place. Right? And oftentimes the ability of your client to get high value contracts, especially involving sensitive data and information, will depend on how prudent the information security policy is, how prudent the trade secret policy is, and what are the measures actually put in place. So sitting down with the technical team, business teams, and defining these measures and defining these in the form of a policy document has some obvious advantages, right? So you need a zero trust information security policy, which is again something that the technical teams and the legal teams have to sit together and define. You need to have enough physical and electronic measures put in place, and from the watchman to the firewall, right? So if you have something, for example, in the field of software and data, you have to ensure that people are not bringing in storage devices. So which means the watchman at the entrance should check for those devices to begin with. You need to provide locker facilities for people to keep their cell phones and laptops outside before coming in and starting work. You need to assign company provided electronic devices and not have them use their own devices, right? So that tomorrow you can check whether any data has been moved out of the company system or not. You should ensure that there is no way in which people can use their personal email addresses to transact using the trade secret, right? So attachments containing trade secrets and confidential information should not be done using Gmail. It must be done on a private domain of the organization. You should have sufficient firewalls put in place. When these things are captured properly in the policy, and it's announced and it's put up prominently in the notice board and emailed to every employee, and the employee signs it as part of the employee handbook, tomorrow when you have to stop that employee from taking the information out, you already have one set of the data you need to prove to the court that you have put in place measures to protect the secrecy of the information. And the last but not the least, you also need to define these policies to ensure maximum traceability and accountability. And to give you an example, I was working with a client of ours that had developed a certain mechanism to ensure the safety of people within the facility. Right? Now, this was in the form of a score that they had developed to measure how many times people have threats to their physical safety coming about. Right? It could be as simple as somebody falling within the facility. Right, and based on that, they had decided to improve the training for the security and the safety staff itself. So in a situation like this, there was that one particular algorithm that was in place to measure the score. And the question was, how do we protect it? So we finally decided to design a policy where the particular system and the algorithm was housed in one particular system within the entire facility, a computer, which could be accessed only by the chief executive officer, the chief operations officer. That's it. Right. So tomorrow, if we have to trace who is the source of the leak, we already have 2 suspects. So this was one of the intent of the policy itself, which is how do you improve traceability and accountability? So when you're designing the policy, you define what, according to you, the organization is confidential information. You define what measures have been put in place. You define the do's and don'ts for the employees in terms of what they can and cannot do, right? The agreement will say that you can't disclose in an unauthorized manner. What qualifies unauthorized usage and disclosure is defined in the policy, right? Where you say, if you use your own computer, violation of the agreement. If you use your own private email, violation of the policy. So this is what the policy is supposed to do. A good, well-defined policy will complement your NDA, make enforcement action that much easier. Any questions so far? Now we come to enforcement, which is my favorite part. I have appeared for both defendants and plaintiffs. I've enjoyed appearing for the defendants more than I've enjoyed appearing for the plaintiffs. But this is a very tricky subject and frankly, really requires you to apply your mind when you're putting together the entire case strategy and trial strategy. Right? The first problem statement in enforcing trade secrets and confidential information, how do you describe it in your plaint or in your statement of claim before the arbitrator? And that's where we go back to the problem statement. Too much disclosure, then the trade secret is lost. Too little disclosure, insufficient notice to the defendant or the respondent. So solving this problem is the first challenge for the litigating counsel, right? And it's important because in multiple judgments across various courts, it has been held that if the plaint does not set out the details in sufficient measure, chances are that your plaint is not maintainable. You could even have your plaint rejected at the threshold without a trial, right? So what do we do? The other problem is, let's assume that we go ahead and give very little detail. We say that, look, I have proprietary software code, it is confidential in nature, he has taken it and he's going to misuse it. You get an injunction order that says that the defendant is restrained from misusing confidential information. The difficulty is, how do you enforce that injunction? Right? Because tomorrow, if you're going to go to him and say that, look, you're violating the injunction by disclosing this data or information, he will say that this is not confidential. I had this even before I came to your organization. But he could come back and say that you are talking about technical data, but I'm only dealing with the customer information. You are dealing with customer information, I'm only dealing with pricing information, right? If you don't have a specific injunction order, enforcement of that injunction is a nightmare. And believe me, in our country, enforcing the injunction is as much a task as getting one is. Because that proceeding itself could take 6 to 8 months. There is a separate trial that is held. A complaint has to be filed. Parties have to take the witness stand. And then finally, an order of punishment comes out. So specific details will mean specific orders. Specific orders means it's easier to enforce. Right? So this is the problem statement that you have to try and solve. And there's one judgment of the California Court of Appeals that is illustrative on how do you solve this problem. It comes back with the standard of sufficient particularity, right? Where it says that the plaintiff must describe the subject matter of the trade secret with sufficient particularity to separate it from matters of general knowledge. Okay. So here you're getting some indications on how do you balance this delicate act, right? So your plaint must set out what is general knowledge and how this is different from it, right? How this is something that is proprietary to you, right? And there are certain practical ways of doing it. So for example, you describe in your plaint the utility or the function of the trade secret or what it is able to achieve, as opposed to showing how it achieves that utility or function. So going back to that engineering design case that I was describing, it was able to bring in certain utilities for the customer, which is that it was reducing friction, it was improving output, it was able to lessen the chances of fire and other safety hazards, and it was being done through a combination of design, the shape of the product and the way in which it is arranged and put together into the tube. It was done using the certain materials. There were certain alloys that the client had developed which enabled this kind of a utility to be achieved. So what we did was that we described the problem statement that it is solving. We described the material, we described the fact that the solution to the problem statement was being achieved through a combination of design, through a combination of metallurgy, and through a combination of installation, right? And we then went about describing what are the steps we have taken to protect it, what was the cost of development, how many awards the company won as a result of the unique design, how much of profit margins we were able to achieve because this was available with us and nobody else, the accolades involved. And the sum and substance of it was that we were able to show that there is something tangible that is worthy of protection. And because there's so many steps taken to protect it, you must assume that it is a trade secret and you must assume that it is confidential information. The court finally agreed with us and actually granted us a decree. Right? So you have to look at abstraction of the trade secret. You abstract the trade secret by focusing more on what it does as opposed to how it is achieving it. You look at providing the most minimal details necessary to show what is the USP of the trade secret itself. Could be design, could be the metallurgy, could be whatever, right? In the context of a recipe for biryani, you could probably argue that, look, the trade secret I have, which is the recipe, has enhanced fragrance, provides a certain unique taste to the consumer, is able to pull in a certain certain scale of customers which other competitors are not able to do. I have ensured that I have only limited knowledge of it to the chef and nobody else. And I've won these many awards for being the best restaurant or the best biryani, and therefore you must protect the recipe, right? Now, then the court knows that what it is dealing with is an action for protecting the recipe, right? Instead, if you say that, look, this person had access to my confidential information and is trying to take it away, the next question that the court is going to ask is, what confidential information are you talking about? So if you don't describe that, your case is already lost. Now, the other problem with trade secrets and confidential information is how do you measure damages, right? It is not at all easy because as it is with intangibles, like be it patents or copyright, damages computation is an art in itself. And there are, in fact, damages valuation professionals who you can employ to really value the trade secret and come back and guide you on what the appropriate measure of damages are. But some of the ways in which this can be done is through understanding how much of cost and effort was undertaken to develop the trade secret. What are the anticipated profits that the defendant is going to make? Because for us, as the developers of the trade secret, there's a cost we have put in. Based on that cost, we are going to make a certain amount of money. My value proposition is the difference between the two. The defendant has no need to incur that cost because he's stolen the trade secret from me. He's only making the profit. Now, the amount of profit that he is likely to make without the cost is a measure of unjust enrichment, which I can claim as damages. Right? The next question that you have to ask yourself is, for how long should you calculate that unjust enrichment when you make the claim for damages? And that is done using the method of asking yourself, how much time will it take to develop this on your own? 3 years, 5 years, and then you say, okay, if that person has to take that much time to develop it on their own, then that is the length of time for which he needs to be injuncted. That is the length of time for which he needs to give you damages in the form of unjust enrichment renditions, right? Or rendition of our account of profits. So there are different mechanisms employed for this. There is no straitjacket formula again. It really depends upon the facts of each case. If the books are readily ascertainable, unjust enrichment and account of profits is a great way to make your claim. And account of profits also saves you the trouble of paying very huge court fee or arbitrator fees, right? Because what you really want in a trade secret action is injunction. You want the proliferation of the trade secret to be stopped. Money may or may not be critical depending upon the facts. Usually, it is claimed as a way of sending home a point that it is expensive to misappropriate my trade secret. But the primary prize is always the injunction. So you file a claim or a suit with an injunctive relief and say that an account of profits needs to be drawn to figure out how much money is due to me. You file the suit with a minimal court fee of 1,000 rupees in Karnataka, right? And you have an order in your favor in probably less than a week's time, as opposed to claiming tens or 15s or 20 crores worth of damages and paying huge and hefty sums of court fee. So you have to sit down with the litigating counsel, or if you're the litigating counsel, you sit down with your client, ask them all these questions, provide all these data points, and then say what the strategy is going to be in terms of the relief, right? And obviously, it's not an exact science. It requires a lot of application of mind. And sometimes where it is complex, always good to bring in certain experts to do the evaluation exercise for you, right? The bottom line is that there are certain principles of restitution, being able to be put back in the same place that you were in before the breach occurred. So there are various theories under the law of damages that you can employ. So you sit down with somebody, figure out which theory best applies to your claim, come back with the numbers, and then go with your claim. Right? All right. So obviously, we will not be looking at just from the plaintiff's point of view. And this is the part that I come to, which I personally enjoy the most, which is how do you defend yourself against an allegation of trade secret and confidential information? So obviously, one of the things that we're going to be focusing on from a defendant's point of view is how accurately detailed is the plaint. Right? And oftentimes, I've been able to get favorable orders on confidentiality for defendants only because the plaintiff has failed to describe the confidentiality in detail. In fact, there was a recent judgment of the Madras High Court, if I remember correctly, in 2022, where the plaintiff took a very creative approach. They filed a very vague plaint, got an ex parte injunction. Defendant obviously came back and said that, look, you need to vacate the injunction. It's too vague what they've asked for. And then the plaintiff comes back and says that, look, the confidentiality club has not been constituted. I was scared that the court record itself might result in breach of confidentiality. So that's why I didn't describe it in detail. So the court came back and said, sorry, we can't agree with you. Confidentiality club is for the trial. Doesn't mean that you're absolved of the responsibility to describe your trade secret and confidential information in some reasonable detail. Need not be too elaborate, but at least some basic pointers need to be granted. So from a defendant's point of view, in 90% of the cases, I've succeeded only on that one premise, that the plaintiff's confidential information is not sufficiently set out in the plaint, right? And then, of course, we've gone one step further to say that, look, there is no access or custody of the information with me. I never had access to it, nor do I have custody with me. I have sometimes gone one step further and said that, look, it's not confidential because the plaintiff had not taken steps to manage confidentiality. I could use my own laptops to work on the plaintiff's business. No measures were put in place to prevent the expropriation of the confidential information from the organization to me. If the plaintiff is so casual about it, the court has no duty to reward him. And even that argument has found some favor with the courts that have appeared before. Then, of course, conventional defenses of information is already in public domain if it is sufficiently disclosed in the plaint, right? And I'll give you an example. In one of my cases where I was appearing for the defendant, the plaintiff said that the customer information, who their customers are, is confidential, and the defendant, being in sales, could take it out and then use it to a competitor's advantage. So during the course of the written statement, the first thing I did was I went to the plaintiff's website. Lo and behold, they had an entire section dedicated to a page called Our Customers, where every one of the customer brands are actually disclosed. And then I went to LinkedIn and I just typed so-and-so manager, procurement manager of so-and-so brand. Got the profile of somebody, took a screenshot of all of that, produced it in my written statement to say that they say that the customer information is confidential, but me as a lawyer who's not in their industry was able to do Google search for 10 minutes, and I was able to get the exact name and designation of the person in charge for procurements to whom my client could anyway go and approach and sell on behalf of the customer, right? And on that ground alone, the entire plane came crashing down on the plaintiff, right? So the clients will come back and tell you 100 things are confidential. Now, the other thing to keep in mind in that very same case, and this was probably an unintended consequence of this, they also had a software that they wanted to protect, right? And it was a comprehensive suit filed for both the customer information and your software, code at the same time. But because this became as trivial, the customer information, the court was not inclined to even examine the issue of breach of confidentiality so far as the software is concerned. So sometimes when you don't do the homework necessary and you don't tell your client that, look, don't bother fighting for something that you won't get, you will end up compromising the relief for something that you could have actually protected. Right? So again, knowing my experience, clients are always in a hurry. They will want everything under the sun to be protected. But if you don't temper down that expectation and remain methodical in your approach, ultimately you could gain some initial traction, but eventually it comes crashing down, right? And then as the lawyer, your neck is on the line, right? Because ultimately the judge has seen you as the person who didn't do the verification before filing the plaint. So remember, as counsels, our job is not just to do everything that our client instructs, but it's also to advise them and to ensure that their expectations are tempered and measured in the first place, right? The other thing, and this is often something that I find very amusing. Confidentiality agreements contain a liquidated damages clause, right? Saying that a pre-agreed sum of money will be paid, and it's a genuine pre-estimate of the damages involved. Now, if you have to get an injunction, you have to satisfy 3 requirements: prima facie case, irreparable harm and injury, and balance of convenience. The moment the harm and injury can be compensated by way of money, the relief for injunction is dead. Right? And by stipulating a liquidated damages clause, you have yourself told the other side that whatever is the breach of the agreement, I can be compensated by way of liquidated damages. Right? You have created the hurdles for the enforcement of the agreement by typing in the liquidated damages clause. So you can't be careful enough when you do your NDAs. You can never take it for granted that one size will fit all. Right? And liquidated damages clause in India, the enforcement is also quite complicated. So why do you even need it in the first place? So always take that little bit of effort to make that due diligence before and entering into an agreement. From a defendant's point of view, these are concessions handed on a platter, and rest assured they will actually be exploited. Right? Now, the other thing is, of course, to also say that even if the plaint is taken at face value, it doesn't make out a sufficient cause of action. That is insufficient description of the trade secret. Plaint is very vague, lacks particular details. There are residual rights involved, right? And I'll come to residuals as a defense now. Sometimes when you work on something long enough, you also develop the skills to develop some things on your own which can compete with the original product. Right? Now, we were dealing with a data analytics product for an NDA discussion once. So the counterparty came back and said that, look, for us, the residuals that come out of the work that you're going to do, that also remains confidential to us, and we own the residuals. Right? Now, my client is the developer of a software. They are the manufacturer of a product. My client software enables them to design their product. Right? Now, the question for us was that because my client's product also employs machine learning and data analytics technologies, every project it executes, every design that is calibrated using the product will result in our client's product becoming more accurate and becoming faster in the way it develops those accurate results. Now, the moment the agreement says that the residuals belongs to the manufacturing customer, it means that the evolution in the algorithms that enables my product to become faster and enables my product to become more accurate, that actually belongs to my manufacturing customer, who actually is not even in the same line of business. Right? Now, this is a classic example where we had to put our foot down and said the residuals clause will not stand. We cannot work with it. And we proposed an edit where we said that, look, If the improvement or the modification or the residual involves my line of business and does not involve your line of business, you have no right over it. But if it involves the improvement in the product you are developing, then of course you get to keep it. Then I will not interfere, right? Now, in the context of trade secrets and confidential information, sometimes employees will retain information through their unaided memory, right? And they take it out and they're able to contribute to their competitors. This you cannot stop, because under the doctrine of privacy, an employee has a freedom of self-development, right? He has the occasion and the opportunity to constantly improve upon himself or herself. So when they take these residuals, enforcement becomes extremely challenging. Google versus Uber was a classic case, where at the heart of the entire dispute lay the employees who were working on self-driving technologies, who migrated from their original employers to the new employers. They had to negotiate agreements in which their new employer was to protect them in the event of there being litigations with the former employers. Of course, what happened later was pretty ugly, and it was not at all conducive for the employees. But long story short, if residual rights are a legitimate defense in a case of enforcement of trade secrets and confidential information, and how your trade secret policies and your agreements are worded will define how effectively you're able to address this, right? So standard definitions of confidential information will always have to be tweaked sometimes. So during the course of the trial, to protect the confidentiality of the information, first and foremost, you need to remember that if you have to summon information in discovery, you need to have a foundation for it in your pleading, right? So if you want to summon, for example, the trade secret itself, without there being a pleading describing what the trade secret is in sufficient details, and then also saying that the custody is with the other party, you will not be able to summon it. So conventional rules of pleadings are very, very critical, right? There is provision for information to be given to the bench in a sealed envelope. There is provision for a confidentiality club, right? Where what happens is a court passes an order describing who all will have access to the confidential information. And through an order of court, a confidentiality agreement comes into place, breach of which will result in even contempt of court proceedings, right? The other thing to do also is to look at redaction, right? When you're submitting documents containing confidential information, you redact the essential details that you don't want the other side to know. And then you ask for in-camera proceedings so the members of the general public need not be present when the proceedings take place, right? These are some of the conventional ways of doing it. If you're going to ask for a confidentiality club, the foundation must again be in the pleading, where you say this is the trade secret with sufficient particularity, and then mention that detailed disclosure, if any required, will only be done on the strength of a confidentiality club, which can be later set out based on the motion by either parties. But without that foundation in your pleadings, tomorrow to make that happen is going to be very difficult. Questions during the trial. Pay sufficient attention to the issues framed by the arbitrator or the court. Sometimes the arbitrator or the court would not understand the technical details involved, and they will frame very, very vague issues. For example, the issue can be whether the defendant has taken the confidential information of the plaintiff. How do you rebut it, right? Which confidential information? So then you have to amend the issues framed by the court by filing an application explaining to the court that this issue in its current form cannot continue. It won't be sufficient. You have to qualify the issue further, right? Because the issues framed by the court is the court providing notice to both the parties saying that this is what your burden of proof is, and this is what you will have to prove. If either the burden of proof is not fixed or the issue is not accurately described, you need to step in and say, sorry, this cannot work. I want the issues to be amended. Because there are judgments to say that if you've gone on the strength of the unamended issues and later it does not go against it, it kind of is to your detriment. You cannot go on appeal and ask for that to be set aside because you had the chance to amend the issues and you don't do it. There are judgments to that effect, right? So be very careful and assess that in great detail and care. Expert evidence can be very critical. The Google versus Uber self-driving case is a classic example. If the defense takes a residual defense, saying that this was something unaided and we were able to replicate this on our own without misappropriating the parent information, sometimes having an expert come in and assess the data and then explain to the court makes all the difference in the world, right? And sometimes you don't know what you don't know, and an expert can help you come and figure that out. even in the context of, say, a biryani, if the same fragrance and taste is achieved by the competing employee with a rival restaurant, right? An ex-employee who has gone out and replicated the same biryani, and the plaintiff takes the stand that he has taken my recipe with him, but the defendant takes the stand that I've achieved the fragrance and the taste using a different set of masalas. Sometimes getting a professional taster to do the assessment and give a report might actually work. Right. So expert evidence has a great role, and it's important to know the industry you're dealing with before you figure out which expert to summon and what field to summon in. Right. And I'll give you a famous example in trademark case. The colors plum and magenta were at the heart of a dispute for trademark infringement between two people in the telecom industry. The plaintiff felt that their color was being replicated by the other color, which is magenta or plum. I'm not too sure. One of them was using magenta, the other one was using plum, or vice versa. So the defendant came back and said that, look, these colors are so obviously different, no consumer is going to confuse the two. So the plaintiff got this cognitive scientist called Donald Hoffman to come and give expert testimony to say that if presented with the two colors, they would probably distinguish it. But if they have to remember the difference between the two colors, without the colors being in front of them, they would confuse the two. Because of that, the plaintiff actually prevailed in the case, right? Who would have thought that a professor of cognitive sciences would be relevant in a trademark infringement case involving the colors plum and magenta? So for lawyers, I think that is the challenge. We have to know every subject under the sun all the time, right? If the lawyer did not realize that a cognitive scientist was relevant, chances are that the plaintiff would have lost. So make sure that you spread your bases wide, know the industry, know the technology, know the law, know everything there is to know about the subject. Otherwise, you may not be able to do justice to the trial. Right? And then also ask yourself, it may be a trade secret or confidential information, but is it protectable or not? Sufficient measures taken, economic value. All those are points for you to probe during the trial and cross-examination. Right? So precautions taken, own devices, personal email address, storage devices, trade secret and confidential information policies. These are all the questions that will come up during trial if there is a smart defense counsel on the other side. So for plaintiff and the defense, they need to be really prepared for answering all of this. And the other thing important to remember is you can never prove that, it won't be a case of a few good men scene where, you badger the witness long enough and he admits to what has happened. So more often than not, you look at three things to establish during trial, right? That the defendant had access to technology, the trade secret. Defendant will obviously try to say they did not. You try to prove that defendant had no custody or control over it. That the plaintiff will try to prove the opposite. And motive and opportunity. That they had opportunity to access and appropriate the trade secret. They had the motivation to do it because of the financial gains involved. If you're able to adequately establish these parameters during trial, chances are that you'll be able to probably prevail in it. Last but not the least, there is a heavy reliance on digital forensics, right? Which is getting an expert to sift through the systems. But again, the best digital security systems like password protection is useless if you don't have a trade secret policy that tells people on how to use it. Like the example of the gentleman who had written the password on the table, right, of the desktop. So you have to address, make digital forensics successful in the course of investigation. You have to have a good policy in the first place and enforce it properly. Then the digital forensics will be able to bring out the trace evidence. But if you don't have the trade secret policy and measures in place, the best digital forensics will probably fall apart and crash. Right? So these are all points to be probed again during the trial. So it will come up. Expertise of the digital forensic expert you have brought in. Has he followed the correct methodologies? Is the data having sufficient integrity? Is this background policy in place? Is the data even able to establish accountability or not? So all these points will come up during trial, which you'll have to be prepared for. So to conclude, NDA is good, but not sufficient. In the absence of legislations, there are legitimate concerns for enforcement. So therefore, you need to undertake a level of due diligence for trade secret protection above and beyond what is available for other forms of IP. There are general laws like the Indian Contract Act and Specific Relief Act that continue to be relevant even for IP disputes, especially trade secret disputes. And very important, I have seen especially suits involving both confidentiality and non-compete reliefs being filed against ex-employees. non-compete clauses, especially after the employee has resigned, is almost always non-enforceable. Now, I don't know why people still make that misadventure of trying to enforce the non-compete clause against the next employee, because what it does is that if a good defense lawyer will come back and show that this is evidence of how unreasonable the former employer is, and that in turn clouds the reliefs even for confidentiality. Be realistic about what can be won and then go after that, right? What cannot absolutely be won, you might as well avoid it, because when you try to mix up the two, the things that you can win also end up being lost, right? So having this sound strategy is very critical. Thank you. This is my email address and phone number if you have any further doubts.
Yeah,
I
definitely.
believe I've completed just in the nick of time. Thank you.
Thank you so
Thank
much,
you.
sir.
Thank you.
And thank you all the more for being here on a Sunday afternoon and dealing with me for my 1.5 hour long monologue. Really appreciate it.
Yeah, thanks,
Thank
Ashok.
you.
Thanks, Ashok. As always, we had a great session today, and you're an amazing speaker, a brilliant session. And thanks again for sharing the practical insight on the topic, to the basics from the pros and the cons in the absence of legislation, non-disclosure agreement to trade secret policy. I think enforcement, damages, and trial. The examples and cases which you gave along actually gave us a lot of clarity on the topic as well. So it was indeed a very engaging and informative session for all of us. And we are definitely looking forward for the other courses you are doing with us on media, entertainment, pharma, and traditional knowledge. And thanks again for joining us today. We had an amazing session.
My pleasure. Thank you.
And thank you all for all the participants. So we had one class cancelled today, which we would be rescheduling it soon. And in the morning, it was on design protection. So I'll inform you all. You will be informed over email. And thank you very much. Thanks again. And have a great evening ahead. Thank you. See you all again.
Thank you.
So much.
Thank you.
Have a nice Sunday for what it's worth. Thank you.
Thank you.
Thank you, sir.